everybody. We are back today for another legal podcast. How are you today, Brett?
Doing well, Nick. How are you?
I am good. The weather is nice. We haven't had rain in a while.
As one of my favorite recording artists sang many times, the weather is here. I wish you were beautiful.
I think that was directed towards Heather.
Oh no.
Listen, I was just told I'm from Philly, so we look for fights.
Yes.
So how is Heather out there in Philly today?
It hasn't rained, so I'm spending more water coming from the city of Philadelphia to water my lawn.
Oh.
And you are in Philly right now, Heather?
Yep. In Philly.
With her water.
With her water.
With her water.
Yeah, my water.
Yeah, it's spelled with two O's over in that part of the state rather than an A.
It is.
But I'm pumped.
Oh, I don't have that button. So today, everybody, we are going to be coupling off of our conversation on our last legal podcast, and we're taking a deeper dive into paragraph 12, which is the section of inspections you can elect.
AKA buyer's due diligence.
Yes.
Inspection.
There are a multitude of different inspections you can do with the standard agreement of sale. So that is what we are focusing on today. We're not talking about vacant land or mobile home. We are literally talking about just the standard agreement of sale, because once you pivot to vacant land, you do have some other options available to you than what you do with the standard agreement of sale. So let's take a look here and I'm going to try to remember them all off the top of my head.
Oh, Lord. Well, wait,
Home.
before you get into that part, there's all those wonderful things that nobody ever reads right before you get to decide.
Well, yeah.
Mhm.
Okay, do we want to cover that first?
Absolutely, because
Okay.
there's a lot of meat on that bone, because before you even set foot in the house, can everybody and their mother's, brother's, uncle's, cousin come to the inspection?
Well, that's a controversial topic.
Even before that,
Oh, you
the
one-upped
same
me, and now he's one-upping you.
and
Let's see how this is going.
that's right. It's gonna be one of those days. It's gonna be it's Tuesday. On a Thursday.
Oh.
It's Tuesday on a Thursday. So I've had this question multiple times. If somebody waives, I'm not going to pick on the drafters of the current iteration of paragraph 8, but if somebody waives the mortgage inspection, the mortgage contingency, but they have a mortgage, they're going to get a mortgage anyway. Are they, can their appraiser, does the seller have to let the appraiser in the house? And, the answer is go to paragraph 12, because, they waived it and therefore they don't get to rely on paragraph 8. You're right. I don't need paragraph 8. I've got paragraph 12. And the seller will provide access to, and it includes in there mortgage lenders and appraisers, among many others, inspectors. So you're right, Heather, your comment that you started out with, that the paragraphs that people don't read.
Yep.
And
8 stands all by itself.
Yeah. And that's, and that was, I remember when only parties and their real estate licensees may attend inspections. Remember when that was added, and it caused a bigger stir at the time than it turned out to be in real life, predominantly among the legal community, honestly, because lawyers read this and said, no, wait a minute. If I show up at a settlement with my client, or not a settlement, a walkthrough, an inspection with my client, does that realtor really think, or depending where you are, does that realtor really think that they're going to stop me from walking into the house?
As long as they have water.
As long as the water's on, it doesn't matter. And when I taught it, when I would teach that paragraph to realtors, I would just simply say, look, if someone shows up with their attorney, don't stand in the way of that, because that you're going to pick a fight that doesn't need to be picked. First of all, I don't know many buyers or sellers that are willing to pay the attorney's fee to go to a walkthrough or an inspection. And that's the big one. Secondly, if they are paying the attorney to go through the walkthrough or inspection, that means you've got something else going on. And the last thing you want to do is find yourself in the crosshairs of an angry lawyer who's trying to find a way to form a lawsuit. And, most of the time, if the lawyer is already a realtor, real estate licensee, and they're representing the buyer, they have the right to be there anyway under the agreement, so that doesn't matter. So practically speaking, to the lawyers, don't get all fired up. How many of you are going to go to the inspection or walkthrough? And realtors, if they show up, is it a fight worth picking?
Correct.
And that's one of the things when going over this as an agent, buyer's agents and listing agents should be setting the expectation with their clients.
Mhm.
Because a lot of people also say, like, well, the seller, seller can't be home. No, the seller can be there for the inspection. The parties to the contract. And I've only had kickback on this when I've had two people who were purchasing a house, but only one was on the agreement of sale. And I made it clear in advance, and we actually made it a condition in the agreement that, so-and-so can attend inspections.
Good idea or bad idea to have the seller present for inspection?
Well,
I
that's
don't
another,
recommend it, yeah.
I don't recommend it either, but I've
Yeah.
had sellers, literally who followed behind the home inspector with a toolkit and fixed everything that they said was broken.
Oh, hey,
But
there's some
but-
dedication to that, I guess.
there is, but again, it's setting the expectation about the parties. I mean, I had an entire family show up to one of my listings for the inspection, and no offense to lawyers, but the seller was an attorney, and I had to bring the agent inside. I said, before we get started, I don't want to make this awkward. I see you have a lot of people here. Are they inspectors? Oh no, it's mom, it's dad, it's this, it's that, it's the other. I said, let me call the seller and see about permission.
Yeah. Yeah, 100%.
Mhm. You gotta play it safe,
Yeah.
because at the end of the day, technically that you're breach of contract.
Well, and the seller or the listing agent at that point has the right to say you can't go in.
Correct.
And I did. They were
Yeah.
still on the front porch. I mean, thankfully it wasn't too hot, and I was able to get the seller on the phone because it was awkward. It was awkward because,
Mhm.
in advance, it's awkward. And another thing is, what are your thoughts, Brett, on listing? Like, I've had some listing agents who are like, yeah, that's fine. And I know they didn't check with the seller because their
Mhm.
reply to me was too quick.
Well, at the end of the day, if you're the buyer's agent and the listing agent is telling you, yeah, it's fine.
Oh, I'm going.
Yeah, you're going and you're taking the bridge club with you.
Yes.
Because you're protected at that point.
My
Right.
caveat to that is make sure that, yeah, that's fine is either in a text message or an email
Yes.
rather than verbally, because
And is email preferred from text message?
I always prefer email over text message, but
I thought that was gonna be our first depends of the day.
no, I prefer it. But in today's world, text
Over
message,
under 5.
yeah, text messaging has become so familiar
Mhm.
that what I want, it wouldn't be my favorite form of evidence if I was trying to introduce it in a court of law. But for what I would be dealing with in a dispute, for something like that, look, I got a text message, my is it the agent's phone number, right? That would be the only thing. Can you establish it's the agent's phone number?
Yeah.
And as long as you can do that, I think, now I wouldn't want to be doing a DM or a PM or a snap snot, whatever thing that disappears.
No
No
TikTok.
TikTok dance?
No,
I only have 7 followers, so
Yeah,
I'll never be able to do a video.
no TikTok, no tic tac, no dough, no toe, no
Yep.
snaps. What is it?
Snapchat.
Thank you.
Yeah.
Yeah, none of that stuff, the things that can
It's
disappear.
okay, I got you, Dad.
Thanks.
Okay.
Thanks, kid.
So all right, so let's talk about another common misconception.
Well, hold on though.
in
While we're
this
still on that
paragraph,
topic,
Okay.
I think it's important to share with buyers, sellers, and agents out there that the reason that is truly there is because you don't want the seller has a right to know who's coming through the home.
Right.
Just because you're under contract, you don't own the home yet. You don't have the right to bring mom, dad, Sally, the next door neighbor, the guy you met in 3rd grade over to the house. You do have limitations to that. And I think too often than not, the understanding or expectation becomes, well, I bought the house, it's mine, I can bring who I want. You don't. So just check. It's better safe than sorry.
Or
I'll
scratch
get
out
off
of the
my
contract.
soapbox.
All right. So one of the common misconceptions under A is that the buyers get 2 pre-settlement walkthroughs. And let's just assume the buyer chose to do no inspections. They waived every single inspection.
Mhm.
They still get their 2 pre-settlement walkthrough inspection. Can they inspect the property at that time?
Well, can the buyer inspect the property?
Yes.
Sure. Buyer's walking through and they're looking at it. That's inspecting. If you're,
But not
can the
bring
buyer
a-
bring a home inspector through? Well, go back to paragraph A.
Ah,
You know, you can't just bring the home inspector through without permission unless you call the listing agent. Say, yeah, that's fine. I'm bringing Joe through. Do you care if I bring Joe through? Yeah, that's fine. The listing agent doesn't ask who Joe is. Joe's the
right.
handyman. Well, you know, so yeah, and it says specifically that waiving any other inspections does not waive the right to a pre-settlement walkthrough inspection. That was a product of the changes to RESPA and TRID back in 2013 to 15. When we thought it was going to be a bigger deal because of the 3-day change to the
Right, and renegotiate, couldn't
Yeah.
just throw a seller concession on at the last second.
yeah.
And you're right. So both of those changes, both 1 and 2, at the time were like, oh, this is going to be crazy. And now looking, in hindsight, it's nothing. It's not that big of a deal.
Correct.
It really honestly isn't that big of a deal. But you did mention about having the water on, and this is one of the other things that we've run into here. Under buyer's due diligence, even though it's rights and responsibilities, it mentions that in all bold, seller will have heating and all utilities on for all inspections / appraisals. Well, if you go back to that A2, it says that a pre-settlement walkthrough inspection. So the seller better have what on? Utilities, right?
Should.
For the walkthroughs.
Yeah, they should. A lot of people don't think about that, but I think you're right.
Yeah, they go and have and that's why I always try to enforce that. Why don't you have the gas and electric turned off the day after settlement, just in case?
Yeah,
Yeah.
do your switch then, not
Right, do your switch
before.
then, right, because that is one of the things. But here's also another thing. You've got agents who are putting properties under contract where they are a hot mess and there hasn't been a utility on in that property in years.
Right.
So we're talking about the Hot Mess Express.
Right. So you have a hot mess express situation, and now you've left A3, 12A3. Could that be problematic?
Yes. In podcast land.
You don't want to say it depends. We've got fun.
I'm avoiding those words at the moment. I'm being passive aggressive.
Because he doesn't want me to win the bet.
Yeah.
I know.
It's it's a bigger problem. It's the same problem that runs into when it's a bank-owned property and they finalize it, and they just say no. What are you going to do? All right, you're in breach of contract. Great. Listing agent, maybe you made a mistake because you didn't read the agreement. You don't know your agreement as well as you think you do, and you didn't take that obligation out. I can't tell you how many times over the last 20 some odd years I've had people say, but the seller didn't have the utilities on, the agreement of sale required it. Okay. Well, what are my remedies? Seller's in breach. Don't buy the house. Well, we still want to buy the house. Okay, buy the house. Yeah, but the utilities aren't on. What do you want me to tell you? The utilities aren't on. The seller's not putting them on. Can we make the seller put them on? No, but the contract says we have to. You're right. Sue the bank and make the bank come out there and do it. Well, they're not going to do it. I know.
Mhm. You're
Where are we?
stuck.
Third base.
Right.
So it is one of those, and then we end up with, well, isn't this agreement worth the paper it's printed on? Absolutely it is. It's just not necessarily worth the lawsuit you're going to have to file in order to enforce the requirement that the seller turn on the utilities.
Yeah.
Well, why is this even in there? Because most of the time it's not a problem. But you need to understand, if it is a bank-owned property, particularly going into or coming out of the winter, it's going to be a problem. If it's an abandoned house, a blighted property, a vacant the utilities aren't going to be on, and the seller's not going to put them on. So buyer's agent, set your expectations. I think you used that phrase a little earlier, Heather. You set the expectations of your client correctly. Buyer, the chances of the utilities being on are pretty slim.
Right.
So, well, can we do them? If we turn them on, the seller's likely to say, yeah, you can have them turned on, but you got to pay to turn them on. You got to pay to turn them back off.
Or just turn them on and leave them on.
Well, but again, the bank-owned property, they're going to say, and they're going to make you sign something that says you agree to turn them back off, have them turned off by the utility.
Or you're fully liable.
Well, I'm not going to spend that kind of money, and we're not going to have that kind of time, so it's not practical. But there are a lot of provisions in the agreement that if we really drill down and talk about them, the enforceability of them, it's not that they're not legally binding, it's how do you enforce them if someone says go pound sand. This is one of those provisions. It comes up regularly enough that it's bolded and it's worthy of us discussing it. But the practical aspect is, as a listing agent, pay attention to this section, because if your sellers turn the utilities off and is not going to turn them on, you want to strike the paragraph. And buyers, you need, buyers agents, position your buyers and set their expectations to understand if the utilities aren't on now, they're not going to be on in 3 days when we go to do an inspection, or in 8 days when we go to do the pre-settlement walkthrough. And understand what the risks are. You're buying a house that the minute you turn on the water, all of a sudden 17 pipes might burst because they didn't properly winterize. It's a risk. Negotiate that, be aware of it, be aware of what your risks are, be aware of what the property is. How many times Nick, you and I know, we know Josh the plumber. How many times have we heard Josh talk about, after the winter, people didn't turn off the hoses, didn't disconnect the hose, and the bib inside the house, they turn on the, first day of spring, they turn on the faucet outside, the spigot outside, and the hose has a trickle out and they can't figure out what's going on. And 20 minutes later, they walk inside and they've got a swimming pool that used to be their basement. Because the bib inside broke because it wasn't properly winterized. The same thing's going to happen if you've had a house that's been vacant. If they didn't properly drain the pipes, the minute you put that pressure through there, if it froze, expanded, then contracted, that the integrity of the copper piping has been compromised. The minute you push through, on level pressure, you're going to have the water park. And buyer's agent, do you need to know that will happen? No. Do you need to know that's a risk that it could happen? I think so. If you're selling a property that's been vacant with the utilities off, your job is to know, well, that's not my job. That's a plumber's job. Correct. It's a plumber's job to fix it or inspect it. It's the realtor's job to identify potential problems. And is this something you care about? Yes or no? Well, I care about if my pipes break. Okay, well, let's get an inspector to look at it. I don't want to pay for inspections. Okay.
Well, take the risk.
Yeah.
Now we're past those sections.
Well, I still like paragraph 5, A5. I really like paragraph. I'm causing Nick to twitch.
Yeah, we're not done. There was 5. We only went through 3, Nick.
Yeah, I like, so we talked the last time about the change to the agreement of sale that requires the buyer to provide all inspection reports.
Oh, see, I don't think about that because I cross it out.
Yeah. And I remember not arguing, because when I was counsel, it wasn't my job to argue for one position or another, but pointing out that, look, you're requiring buyers to turn over inspection reports because of the debate that's going on. When I say I don't want it, they send it to me anyway. But the ability to request them is already in there for the seller, and it has been for many, many years, that the seller has the right upon request to receive a free copy of any inspection report from the party for whom it was prepared. Unless otherwise stated, seller does not have a right to receive a copy of any lender's appraisal report. And for many years, I've had buyers and sellers that have used that well before we had the home inspection law and well before the PAR changes to paragraph 13. And in fact, at one point I had a buyer who went through and struck that word free because he intended to have they were concerned about groundwater pressure, and he intended to have a hydrostatic engineer come in and test groundwater pressure to find out the reality of the water in the basement. And he said that report is going to cost me somewhere between $1,800 and $2,200. And I don't mind paying it, but I'm not giving it to the seller for free.
Yep. Perfect example. We were negotiating. It's the one I called you about last night. On that, we're looking to do a water test or a well test, a septic test, boundaries. Right there, those 3, that's about $6,000.
Yeah.
Like that's not cheap. So yeah, that word free is gone.
Yeah. And what would happen a lot, and so what can happen now, if you get the the cranky Nick who goes through, not the wise Nick, just the cranky Nick.
That happens a lot.
Who goes through, and now usually wise Nick is still in there when it comes to drafting the documents. it goes through and strikes out paragraph 13 where it says I have to give the report,
Mhm.
but you forget to strike out paragraph 12A5. And now the seller says, ooh, I can still get a copy of the report using that 4-letter F word
Mhm.
free. And now Nick is reimbursing his buyer because cranky Nick forgot to scratch out A5.
So what's great is about zip forms that is a benefit from PAR that we all have as realtors. You can build templates
Mhm.
that automatically remember everything you do. So it is literally struck
Stricken.
because of you.
Strucken, it's
Automatically
strucken.
now, same thing. Automatically now that when I open it, it's just automatically poof gone. And that's only because of how much you preach to me about the importance of listing to you.
Wow, good. I'm gonna have to have you come over and teach me how to use my Lone Wolf program and how to set up templates because I forget some of the things I like to have out of the agreements.
I'll check it.
I use 5 times a year, 6
Yeah.
times a year.
It's awesome. Absolutely
That
awesome.
does sound
Because
like a
now
good
I
tool.
don't have to remember. It's just literally boom gone.
Oh,
So
Lord.
are we safe?
We're done with A.
Well, we're
Okay.
done with A. Now you have B and C, which are easy enough because B is just the buyer is either waiving or electing at their expense to have these inspections done. And then
Correct.
it goes into the professionals who
Well,
can
hang
come in
on.
the home inspection law.
Yeah, that's what I wanted to draw the spotlight to is all all inspections shall be non-invasive unless otherwise agreed in writing. If the same inspector is inspecting more than one system, the inspector must comply with the home inspection law, which is problematic in different ways because one of the talk about a waste of 63 pages or however long it is in the statutory book. I can't, do you know what that says? Do you know what the home inspection law says and what the requirements are? And are you doing it? And oh, by the way, how many national organizations remain so there's one that I know of that is still viable. And so if your home inspector is not a member of InterNACHI, they do not qualify to do an inspection under the agreement of sale.
Interesting.
People keep telling me ASHI is still out there. I've heard that ASHI is not. I don't know whether it is or it isn't. So I'm not
They
making,
still have a website.
but whether or not it's functioning at the level that it's referenced in the home inspection law, I don't know. Do they have?
I call them ashy.
They call them all kinds of things too.
Call them ashy.
But at the time that the law was drafted, you had ASHI, you had InterNACHI, you had NACHI. Well, NACHI folded. So it might be something that, I mean, I don't think that PAR has a lot going on right now with reviewing forms, so it might be something that they
Should take up.
put it on the agenda.
Like that's an emergency.
It's not an emergency, but at some point, it's kind of one of those things that's lurking out there. That if I have an inspection, I elect to have an inspection done. And I have a home inspector come through, and if I'm in year now, Nick has the home inspector. And I'm the seller, and he wants, because there's a problem with the foundation, he wants to have it done. And I'm gonna wait till the end of the inspection period, and I'm gonna say, he's gonna say I get to terminate because we went into we went out of 10 into 5. And I'm gonna say, your inspector's not a member of ASHI or InterNACHI. So your inspection, you didn't have an inspection done in accordance with the home inspection law. So your buyer's got to buy the house with a cracked foundation. Too bad. So
That makes Nick even crankier.
it's not a real life problem today, but it also wasn't a real life problem about using the TERAREL, people just using the REL when they wanted to terminate. In our 10-5, when I want to terminate, they send the REL. It was fine for many, many years until a very savvy buyer agent ignored the request from, or it's very savvy listing agent ignored the request from the buyer agent until the time lapse. This was well before the 10-5-2. And then finally, after it expired, the buyer's agent finally said, "Why aren't you responding to me? You owe us the money." And the listing agent said, "I was waiting for you to terminate the agreement. You never did. So your choice is buy the property or forfeit the deposit."
So it's so funny you say that. So side note, I had about 4 or 5 months ago to where a listing agent, we were having a debate on the appraisal. And he decided that he was going to counsel his client to just terminate the deal when it wasn't his right. But instead of actually terminating the deal, he just sent me a release of deposit.
I remember that.
My client got the money back.
Mhm.
No, what tell you.
Yep.
Yeah.
Oh, that buyer
You
got their
pay
money back
attention.
too. They got it back from the buyer agent, not from the seller.
Right.
So, I mean, it's, you know, it's real life, you know, it's not a problem. Like I said, it's not a problem now.
Yeah.
It is a potential,
Mhm.
the reason, why isn't it a problem? It's the same reason, you know, when Nick calls me and says, is this illegal? And my first question to him is, well, did you get caught?
Oh, Lord.
No, technically, first question is your retainer paid? And then
Oh, Lord.
it is, did you get caught?
Is this a criminal question, Nick, or is this a real estate
Oh,
question?
Lord. Oh, Lord.
Oh, just saying.
Oh, Lord.
Just
And when
saying.
he asks me if there's a difference, I know it's time to crack open the bourbon.
We
All
don't
right.
have that here.
Well, Nick, now's your time to talk
Yes.
about your, what is it? Is it
You list
8 or
them?
9 items?
So let's see. So actually it was hilarious. I was reviewing a
10
contract
items.
with a client. She was signing it. We were going page by page. She goes, do you have this all memorized? I said, to a point. I said, eventually I'm going to say I have to walk back to my laptop so that you can laugh at me then. So, okay. So you've got home inspection, which is also environmental and mold.
Okay.
You've got water. You've got radon, and I may not be going in order. You've
You're
got
not, but go
pest.
ahead.
You've got septic/sewer. You've got property and flood. You have boundaries. You have deed restrictions and usage, or whatever, however that's worded. Other,
And you missed one.
1978.
hold on, lead-based paint.
That's-
And yes, that was not an
It
order.
it was long before I was born, so of course I don't remember. Nothing existed back then.
Right. But also keep in mind, environmental is just not mold.
Oh yeah, environmental is anything environmental dealing with the property, you know, oil, all of that fun stuff. That's why but it also says including mold.
Right.
So it is fully environmental. So
Etc.
that's the next thing though. How many people have home inspectors in there that are looking at the environmental stuff of the property? Now, you don't always need it, but if you know that there's a tank buried somewhere on the property, you might want to consider having an environmental specialist
If you
look
know
at
you
it.
have, your buyer has a severe mold allergy
Uh-huh.
and you're in
Mm.
Pennsylvania and it has a basement, you might want to have a mold remediation company or, you know, a
Yeah.
testing company go in to test it.
Yeah.
Um,
There was a girl that last year when we kept going into properties, she started having problems breathing. She's like, nope, this is out. We're done. We'd leave because
Yeah.
there was mold.
Yeah. So one recommendation for buyers who are out there listening, unfortunately, sometimes home inspection companies or inspectors will tell you, oh, well, if we see anything, then I'll suggest it later, blah, blah, blah. If, like Brett and, you know, Nick said, if this is an allergy, don't wait, get it done, because it could take sometimes 5 or 6 days, depending on the lab and depending on what was, you know, what took place to get back. So,
correct.
And then here's the next thing that I tell everybody. It's never my recommendation for you to waive your inspections. Now, I always tell you that your offer may be less desirable to the seller, which for some reason there's this persona that having a home inspection is a bad thing. In my opinion, I tell all my sellers, why do you care? It's a Kevlar Snuggie. Let them do it.
I would tell you, and I've told you this, Nick, but I would tell you, if you're a listing agent, the smartest thing you can do for your sellers to protect their post-settlement liability is encourage them to tell a buyer's agent, elect a home inspection.
Yeah.
Whether you do it or you don't do it, elect a home inspection, because if you've elected it and not done it, I can say you had the right to do it. If you find an issue that's unsatisfactory to you, then we can address it now.
Mhm.
And it's a lot easier and far more economical for a seller to address a problem unearthed by an inspection while they still own the property than it is after they've sold it.
And when you think about it, you know, you have to think about your liability down the road because you are still tied to the property. So I know myself, I don't remember half of what I did yesterday. I don't remember what happened with my property when I bought it in 1999. Like, I don't know these things. Obviously, I was too young to own property then because, I mean, look at this face. But But like you don't remember, did you have a flood? Did you have this? Did you have to replace that? Did you replace this? It becomes very costly that you forgot something by accident, not on purpose. It wasn't facetious. I think I said that right. I hate that word. That then it's found after they move in, and now they're calling Brett going, hey, it's time to file a lawsuit. They didn't put this on the or they didn't put this on the seller disclosure, and there's a line for it. They lied. Now you're getting attorneys. Now you're also probably going to have some mitigation fees that you're going to be paying. There's cost of homeownership. The cost of letting a home inspection happen to a seller, in my opinion, is not one that you really truly want to pass up, even if they ask for a few things. The last one I dealt with, they asked for things that totaled less than $1,000. Guess what? In 7 years, the next 7 years, she doesn't have to worry about being sued for, oh, I didn't realize that breaker was double tapped.
Right.
And the house caught on fire and burned out.
Right.
Well, it didn't, because we caught it and it's fixed. But, let's be honest, that is a safety feature. A double tapped breaker could cause a house fire. And then that's the seller if they find out that, oh, well, they just bought it last year, it burnt down this year, and it was because of that, and she didn't disclose. Like, I'm not getting involved in that. Make me some popcorn though.
Well, how often do sellers stick their heads in and know for a fact that it's
Correct. You hired that handyman to do it, and they
think-
weren't prepared to do it or inept to do it, but they wanted your money and they didn't want to say no.
My God.
And now you got an issue.
You want to go with the cheapest number out there.
Yeah.
So Brett, are there any recommendations on any of these, that you would say are underutilized or
Yes.
or misrepresented in what they truly are? So give us
Or not understood.
Yeah,
Right.
deeds restriction and zoning is the most underutilized, underappreciated, misunderstood contingency on this entire form.
Which this goes
People-
back to, for those of you that are serial listeners, our title podcast with Brett, we touched on this as well.
Yeah.
So
when a lot of people and realtors, consumers, even attorneys don't understand what title is doing behind the scenes when you're getting ready to purchase the property. And what title does is title checks to make sure that you, the buyer, are taking ownership of the real estate in accordance with the title paragraph in the agreement of sale. Title is ownership. Title is not use. I want to put a pool in my backyard. Great. There's a deed restriction that says no pools in the backyard. Let's call and sue the title agent. Title agent says, not my problem, because that doesn't have anything to do with ownership. Well, aren't you supposed to tell me? No, I'm not supposed to tell you what you can and can't do with the property. I generally don't know what you want to do with the property. So restrictions, it's too many times realtors focus on HOA restrictions. Those are the easy ones, guys. I mean, title's not going to review the CCs and the conditions, covenants, and restrictions. Title's not going to review the bylaws. Title's not going to review rules and regulations, because title doesn't care. Title cares about one thing in the controlling documents. And does the HOA have a right of first refusal to the unit? And that has to be disclosed on the resale certificate. So really, title's looking at the resale, right of first refusal, check no, great, we're going to close the deal. Whether or not you can actually do something with the property, it's the non-HOA restrictions that are bigger attention grabbers. And I don't mean the ones that are based on discriminatory classes or things like that. But what about, no unlicensed vehicles being parked in the driveway? Well, I bought a boat. Do you have your boat sitting on a trailer? Do you have a license plate on the trailer? Yes, I do. Great. Do you have the current license on your boat? Because you need to have a license on the boat. No, my boat doesn't have the license numbers on it. Now you're in violation. You can, you've got to move your boat. No commercial vehicles parked overnight. Heather, is your car wrapped?
Oh, yeah. Is
That's
it
a commercial
commercial?
vehicle.
That's considered a commercial vehicle.
Arguably, it's a commercial vehicle.
And
So-
it only takes one to make that argument.
Yeah, and now you're fighting over, wait a minute, it's a Mini Coupe. There's nothing commercial about it. You put a wrap on it that turned it into a commercial vehicle. Maybe it did, maybe it didn't. Hey, the sellers are selling the house and because they bought the house with the in-law quarters to take care of their elderly parents. Parents are no longer elderly, they're now dead, and now they're selling the house. It's perfect because my parents are elderly. Let's move in. Well, they were using it, so I should be able to as well. Well, now you've got the municipality's attention because you've got a change in ownership. And now you found out after you bought the house that you can't have a separate in-law suite. It's a zoning violation. So your buyers want to do things with the property. And if they want to do anything other than move in and live inside the four walls, if they want to use the exterior and they care about how it's being used, the deeds, restrictions, and zoning contingency matters. I've had, and again, as you both know, markets determine practices for realtors. As markets change, your day-to-day practices can change. There was a period of time I had some realtors who would use my title agency on a regular basis, and they learned after I got to say, my favorite words to be able to say to anybody.
It depends.
It is not, it's I told you so. And when I had an agent, they got in trouble with a consumer because they couldn't do what they wanted to with the property. And then they said, well, why didn't, I told you so is what I said. You should have had the contingency elected. And so what they started doing was they elected the contingency, and they would call me and say, how long is it taking to get a title search back? And it's taken 7 to 10 days. And so they would make it a 15-day instead of 10-day. Or they would go to the, they'd go to the paragraph that allows you to extend the particular time of the contingency or the CTA, and say that we would change the inspection period only for the deed restriction and zoning, because we want to check title to make sure that we can use the property or that there aren't any restrictions. I had someone buy a house and it said no fences. And I'm like, well, wait a minute, I'm buying it. I've got a dog.
Playground equipment.
And they said, well, in this one, it was a neighborhood, condos, no association. And they said, but everybody else in the neighborhood has a fence. And they said, what do I do? And I'm like, well, the choice is up to you. But if someone tries to enforce the no fence against you, they're going to have to enforce it against every other property that has a fence and a no. So they did their own legwork to look at all the other houses on the street, not all of them, there were maybe 40 houses, and they looked at about 15 or 20 of them. They all had that restriction. They bought the house and they put up a fence. And I can't tell you to do that because that's breaking your condition covenant restriction. But that's why you do, and that's what I looked at the property. I said I knew they wanted a fence. They had a dog, and I said, look, there's a restriction on here. You need to look into it to see if people are enforcing this or not. So a very important, contingency. And there are so many deeds out there, even in central Pennsylvania, which I often refer to as the association capital of the world. But even still, we have a lot of restrictions on deeds that say you can't do a business. Well, I'm not running a business out of my house. I'm running I've got a home office. Is it
You're running a business.
Yeah, I can make an argument either way on that.
Could. Yeah.
So your office, two of you are realtors. And if, I ask you, do you have a home office? It's kind of a setup question, because you're gonna say, yeah, I have a home office. You two might not, but the average realtor works at home and they have an office in their house. And I said, do you have a home office? Yeah, I have a home office. Is it licensed? No. Then it better not be a home office, because under the licensing law, if you have a home office, not only does it need to be licensed, it has to have a separate exit and entrance to the house. So if it's on your second floor, you need to put a staircase. But really what you're doing is you're working at home. You're not seeing clients, you're doing paperwork. And so I'm not running a business out of there, but those are the kind of things that
Heather should really think about getting a home office, because hers is so far away from her house.
Listen, on trash day, it takes me an additional 2 minutes to get across the street.
So I think to me, that is the most overlooked, underutilized, underappreciated, misunderstood inspection on the form. I think that
What's number 2?
it's either boundaries or water.
Ooh.
And I say, the reason I say either or is because if you're in an established subdivision or an established neighborhood, the boundaries are generally what you see on the land, what you see when you go to the property, not necessarily where the legal description says they are, without getting into legal arguments about how boundaries can be changed or not changed. But if you're buying a new house, a new development, or if you're buying, not in a development, you're buying a house, you're buying raw land, the builder promised to put stakes, pins in the corners. And the builder's going to go out there with rebar and stick them where he thinks they should be, not necessarily where they are. The only way you can know where your property lines are with any certainty is a professionally licensed surveyor. And they go out there, and the only way you can actually rely on it is if they pin the corners and cap them with their seal. And people say, well, I got the wooden stake with the pink ribbon on it. And I'm gonna
Which
pick
kids could move.
well, I'm gonna pick a little bit on Philadelphians, but I could do it if you were from Pittsburgh, I'd pick on Pittsburghers a little bit, even though that's my hometown. Anybody living in a city doesn't appreciate this. So once you get out into the country, out of the suburbs and into the country in Pennsylvania, there's an odd chemical equation that's in the dew. And so you get the wooden stakes, and when the dew falls in the night, those wooden stakes, they grow feet and they relocate themselves mysteriously, and it's never to your benefit. It's always to your neighbor's benefit. So relying on where that pink ribbon is or that wooden stake is like relying on your 6-year-old to tell you the truth when they didn't do their homework. Do so at your own risk. So that can be very important. And many times, I can't tell you how many times I've seen surveys done after people move in and the neighbor's driveway is on their yard or their driveway is on the neighbor's yard. I had a client right now. I recently sent out a letter on their behalf saying to the next door neighbor that, my clients own the property, you sold it to them. They're building a house on there. By the way, they had the land surveyed. They had to do that to get the approval to build the house. And your fire pit and landscaping is on their land. And so, and what my client said.
Was it you that shared that? So I recently heard a story, I think it was you that shared this, that is a property, 2 separate properties were owned by the exact same person. They sold the property that had the house on it, but they didn't sell the vacant land beside it.
Right.
But on that vacant land, there was a garage built, and over half of that garage was technically on the land for the house.
Yeah.
And nobody asked, nobody did anything until a survey got done. And now it's, hey, owner that sold us the house that still owns the land, the garage that you kept and said was on that side of your land is not.
Right.
And it had to be deconstructed and reconstructed because of that.
I've had many times where that's been the issue, and we've had to buy and sell easements to avoid tearing down a house in one case. Because if you want to know where your property lines are, the survey is the way to do it. And is it necessary? In Pennsylvania is only one of a handful of states where a survey is not the routine part of the transaction or required in the transaction. It's less critical in an established neighborhood because you have hedgerows, you have fences, you have driveways, and if people have been there for longer than 21 years or the house has been there, then you, to some extent, may be able to rely on what you see, but you still may want to know. Now, if you have a problem when the neighbor cut down your favorite tree, my first statement to you is at that point is get a survey to find out if it really was your tree. And most of the time it's not. It was the neighbor's tree. The other would be the water, and again, this really would apply to you, Heather, and you, Nick, and any other realtor listening that is in any community that has water piping that can have some lead pipes somewhere in it.
So for us, it's the water. For Heather, it's the water.
Yes.
Don't mess with my water lines.
But here's the other thing about how many times have you been your water lines? I don't want to know about your water lines. How many times have you had this is going to go in the wrong direction. I already know it. But when you have a flow issue in the house, this is not the water pressure isn't heavy enough. The plumber that's wanting to sell you the pump to increase the flow. But the water service contingency. Buyer may obtain an inspection of the quality and quantity of the water system from a properly licensed or otherwise qualified water well testing company. If and as required by the inspection company, seller at seller's expense will locate and provide access to the on-site for individual water system. Seller will restore the property to its previous condition at seller's expense prior to settlement. However, it says may obtain water/well. I can test the water in this borough of Mechanicsburg, or I can test the water in a row home or a brownstone in inner city Philadelphia to make sure there is no lead content that I'm not happy with in the water, or that the water is flowing and giving me the water pressure that I want in the shower. All of those things, but everyone that I talk to views the water service to be used exclusively for a well. And it doesn't say exclusively.
You're right.
And in my opinion, I wouldn't need to test my water, but if I was going to Philly, I'd be testing that.
Yeah, so in parts of Pittsburgh, it's the same way.
You don't know how much chemicals they pumped into that
Or
water.
is it coming straight out of the Mon River?
Correct.
You know?
Correct.
It's okay if it's coming out of the Allegheny. It's not okay if it's coming out of the Mon.
I don't think it's okay.
The steel mills are on the steel mills are on the Mon River. So I think those are probably the three biggest misused, misunderstood, or underutilized inspections. The biggest one to me is the deeds restriction and zoning, because those are the most frequent, other than a not having the inspection done and running into those easily avoidable problems. It's the inability to use my property the way I want to use my property, and you can't because it's in the deed. And why didn't somebody tell me?
Correct.
And the answer there is, well, your realtor had the right to tell you could elect that contingency.
So I think the next one that I would point out would be, and I think a lot of people really need to pay attention to this, is the homeowner's insurance.
Yeah.
So everybody thinks it's just for flood, but it's not. It's homeowners and flood insurance.
Property
and
flood.
Right now, homeowner insurance companies are being so picky with every little thing. In the past 30 days, I've heard of 2 people where the insurance company has said, we will not insure that house.
I've heard that.
Period,
I've
point
heard that.
blank.
Yeah,
There's we're not even doing high. We're not even doing, major premiums. We are not touching that property. And it's because, let's be honest, the insurance companies over the past few years have really lost their ass and are losing so much money that they are being pickier. But I think that right now, because of those facts, that is a big one you truly don't want to waive, because now,
or you want to make that phone call as soon as possible.
Correct. Or you could even make it before you buy the house, as long as the deadline's not 3 hours after you saw it. But, and here's the caveat, and I don't like this caveat. I do not like this caveat. Do not do this caveat. This would be a caveat you and I would be having a very pointed conversation with over the phone that you are not going to enjoy. Using the mortgage contingency to back that up, because having homeowners insurance is part of the mortgage. You can't have a mortgage on the property without homeowners insurance. That is not a suggestion of what you should do. I'm just saying it has happened and I'm not happy about it, but we're not going to touch that subject right now. But get it. Because if the home's not insurable, or if they want to say, you thought your premium was only going to be $1,300 a year, but now you can't source how old that roof is, and the insurance is going to be $3,000 a year, are you still buying it?
What if you have a significant claims run?
Claims.
And now you've got to, need to understand.
It runs with the property, not the person.
What triggered the claim? So maybe you need to do an appeal. What triggered the claim? Were your claims based on the fact that somebody stole my wallet and used my credit cards, which claim could fall under homeowners insurance?
I didn't know that.
Or the neighbor's tree, the limb fell off and fell on my
roof
car
and
busted up the car pretty good. Now I got a homeowner's claim. It's not an issue with the property that should affect the insurability of it. So, if your agent or broker is just pulling a clue report and they see the plot claims loss run, and they see that we've paid out, they paid out $50,000 in the last year. Oh no, we're not going to do it. Let's appeal that and find out what the claims were.
Really were.
Because if it was, arguably, if it was a stolen credit card or a tree limb fell on a car, then maybe you can get the insurance at a reasonable rate because it wasn't a condition of the property that should affect the insurability.
Yeah.
But but you're right, sooner the better, because that's not going to be an answer you're going to get on day 9 in time for your day 10 decision.
Yeah. Yeah. So Heather, it's your turn. Which one's your favorite?
Oh, all of them are my. I like other. Actually, to be quite honest, you want to know my absolute favorite part?
Yes.
It's actually underneath of blank option.
Inspections elected above do not apply to the following existing contingents and or items.
Yep. It's actually my favorite part.
Tell me why.
Tell
I've
me
never heard
why.
anyone say that before.
So reason being, especially listen, we know the roof is shot. Don't come back at me asking for a new roof. I know the hot water heater. I'm sorry, not the hot as in it's great looking. The water heater.
The water heater?
The water heater
Water
is the water heater is beyond
I'm
its
gonna
life
Google water
expectancy.
heater.
Oh Jesus. Or the heater is older, things like that, where it's off the table. Like, do your inspections. We know they're old. Like, we know that.
Doesn't mean you're asking for it.
Right. I honestly think that section is very underutilized.
I agree. I almost never see anything in that. Now, as I reminded somebody the other day, I don't ever see the good files.
Oh.
Nobody hires me to come in and nobody wants to pay me to look at the files that are good. It's always the files that things are bad. So, there's the caveat. Why do I say I see it all the time? Because I see the bad files. Well, my files are always good. Well, maybe they are, maybe they aren't. We haven't had a conversation yet. It's uncomfortable.
Have you been caught?
That's right. Have you been sued yet? And I got a phone call the other day from somebody, and it started after we got through the night. Someone I hadn't heard from in 12 or 15 years. And it was this pleasantries. How are you? The reason I called is I've been doing this in over 37 years and I've never been sued. And guess who came to my door today? The sheriff. And I first thought was, did you shoot him?
Oof.
No, but I got the deputy instead. No, just kidding.
Well, I'd say he's here all week, but we eventually have to end this.
Yes.
I need a set of drums on this.
That was a bad joke. It was. But
I guess I could do. I know we
Yeah,
can't.
no, that's it. That's it.
I'll trust.
It was the womp womp
That was a
womp.
womp. Yeah. Well,
I gotta get into using them more.
yes. So you were saying before we went down, I shot the sheriff route.
So I actually like that section because I think it's underutilized. I really honestly do.
So not only is that section underutilized, I think the expectation that realtors are setting to their clients when touching all of them, is the simple fact of this. These are to be reasonable and not unrealistic. So when you're asking for something like a sink stopper to be replaced, you got to put yourself in the shoes of the other individual. And this is how I explain it to my clients. Whatever you're going to ask for, if you were the seller and you were being asked for these items, would you feel that they're reasonable? Yes or no? If you're asking for a sink stopper and you feel like that's reasonable, I'll slap you later, but it's going to get turned down. It's a goddamn sink stopper for $15 at Lowe's. I will get it to you for closing, seriously. And I say that because I've got that as a seller. I've got that on the seller side. And I just looked at the girl and I said, are you... I just want to check. Is this a joke? Are you trying to punk me? Where's the cameras? I've always wanted to meet Ashton Kutcher. But be reasonable. Don't, I got this last one. A set of clients, they won out against an offer that actually even waived the inspections. They did the inspections. They sent through double tapped breaker and boots on the roof. And I'm like, these are reasonable asks. It costs less than
When you say
$1,000.
Boots on the roof, what do you mean?
So the pipes that come up for
Gotcha.
those,
I wanted to make sure
the
you didn't mean a
boots.
pair of shoes.
No, the boots.
Also a reasonable request is get your shoes off my roof.
Get your shoes off my roof. But they were reasonable. And that is something that then the seller will look at and go, okay, I see all the other little stuff that, general maintenance, that you weren't being nitpicky. Like, it goes a long way. So you can get stuff. Just be reasonable, people.
Let me ask both of you a question, and it's a serious question. I don't ask them very often when I'm here, but
Do we want it on air?
yeah,
Okay.
it's relevant to what we're talking about today.
Okay.
And it truly is something
Look at how scared Heather is.
I know, I don't understand there is when did this aversion to inspection contingencies evolve in Realtor Nation?
Oh my God, when the buyer's agents felt that it gave them, gave their buyers a leg up, they started suggesting it.
So I think that a lot of
blame
it
California.
happened when you were doing when you had the 14, 15, 16 offers on a home.
Uh-huh.
What was the easiest way to make it get to the closing table? Oh, and stand out, wave them
Yep.
so that the seller doesn't have to fix anything.
So let me ask it as because you both represent sellers from time to time, right? I presume you do, Heather.
Hell, this year it's been
Okay.
primarily my business.
Yeah.
What is it about the mentality of listing agents that makes you think that's a good idea, that's a good offer when you're waiving the due diligence? I mean, that's kind of what I really want to know, what the thought process is.
I had one seller who kicked back and said, no, I want them to do inspections.
Right.
And I mean, we listen and listen, all honesty, Brett, on the receiving side, you sit there and you explain it to the sellers, and the sellers look at it and say, you know what, is it worth the gamble in some case? I don't know, because they're not voicing that
So
opinion.
tell me what gamble?
The gamble that just exactly what is happening in our industry right now, which is buyer's remorse.
Correct.
And they're coming back and saying, well, I didn't know about this, and I went into the house and I did this, and I opened up a wall and I found this, and seller didn't tell me this.
So that goes back to my question: is why are listing agents encouraging, advising, recommending sellers to accept offers where the inspections are waived?
I'm gonna go with ignorance, only because perfect example, my property up in Schoolhouse, I got a call the other day, hey, no, we're thinking about putting in an offer. They wanted to do a roof inspection. I'm like, great, put it in your offer. They wanted to go ahead of time. I'm like, no, put it in the offer. Like, send it over. Like, I'm not scared. Hell, do them all. I don't care.
Right.
Like, they don't scare me. They shouldn't scare my clients. Yeah, let's do it. Send your offer. But I think that there's a lot of people that have the fear of, well, then you could terminate, then I have to relist it, then I have to do this. Well, no, as long as it's a reasonable ask, why is the seller not going to want to do it? Exactly, because you're still not out anything, you still have the house.
And Heather, I can tell you in a minute what answers I get when I ask this question, but I'm just curious because you guys are definitely
So my answer was ignorance. What's your answer?
You guys aren't what I would call typical agents. You guys are operating at a higher level.
I don't
Oh,
think
thanks. Get the calendar market down.
I
He gave us
wouldn't
a compliment.
necessary it's ignorance. I think in some sellers' cases they look at it and say, well, they had an
No,
opportunity.
agents, not sellers. We're talking about agents, and please know I'm using the word ignorance in the manner that it belongs.
Okay.
Unknowing.
But at the same
Not-
token, you as an agent can say everything under the sun, and it's ultimately the seller's decision.
Yes, it is. It
And
is.
there
But he's
has
just
been
asking
times,
agents.
right? And there has been times where I've said to the seller, they're waiving it, but here's what could happen. I'm giving that advice, and they're still like, okay, it's worth, roll the dice, or they're saying, what, I can't force the buyer to do an inspection. And I'm saying, well, you could counter it.
Yeah, and I've actually done that, advise the seller to do that, is go back and tell the agent to at least elect the inspections.
You don't actually have to do them, but elect
Whether you
it.
do them, you don't do them. My seller wants you to have the option to do it. The objections that I hear from agents most often is things like, well, we don't want a bad inspection report, or then we're gonna have to deal with the items in the inspection report. And to me,
What's a bad inspection report?
there is no such thing, in my opinion, as a bad inspection report. There might be incompetent inspectors, inspectors who do a bad job or have a bad day. But an inspection report is nothing other than information.
Mhm.
And information is inherently neutral.
Mhm.
It's data. And you know, I sort of agree, Heather, with your comment that it's the seller that makes the
Drives the bus.
decision. But we all know that in a startlingly high percentage of the time, the seller's looking to the agent and saying, well, what do you think I should do? Or what do you think, which offer do you think is better? And the agent's saying, well, this one's cleaner, or this one's gonna get us to closing with fewer problems. And I think it's a short-sighted
Mhm.
situation. And when an agent says, well, then we're gonna have to deal with the problems. Well, if there are problems, you're going to have to deal with them at some point
Which
before
is
closing,
true.
or after closing. Well, my seller doesn't want to make the repairs. The seller never has to make a single repair.
I love that when they put on the MLS, homes being sold as is. Have you been to Pennsylvania lately? All homes are sold
Everywhere
as
homes are sold as is.
is. Just
As
saying.
is, you know, and the mistake that says when I put it in there, the buyer can't ask for repairs or corrections, or if they ask for it, I don't have to take it to my
Correct.
seller. You're wrong in both cases.
Correct.
You know, the estate seller who says, we're not accepting any request for repairs. Okay, guess what? If the buyer's agent on behalf of the buyer says to the listing agent, we want your seller to do these things, your obligation under the law, and if you're a realtor, the code of ethics, is to carry that back to your seller.
Mhm.
Well, my seller's not going to consider it. That's fine. Your seller can come back with a no. But your obligation, and well, I
It's
told him that
presented.
he wouldn't have to entertain these requests. And well, that was your mistake and your misunderstanding of both your legal and ethical obligations. You know, when did I always almost said we as realtors, and because I'm not a realtor, but when did realtors become afraid of information about the commodity that they're selling? When did they become
Mhm.
afraid of information about the real estate? I think maybe when the numbers skyrocketed at different times at an alarming rate, and education and training maybe suffered, the value, because there's value in due diligence, not just for a buyer, but also for a seller.
Okay.
And I am aware of a lawsuit in which, the listing agent had two offers. The higher offer included an inspection contingency. The lower offer waived the inspection contingency. And the seller said, which offer do you think you ought to take? And the agent said, I'll take it's a higher offer, but the waiving the inspections is going to be better for you. And so after the buyers bought the home, they did an inspection and found a problem with the roof. And now the seller's being sued, and the seller's saying to the listing agent, suing the listing agent, saying, you breached your duty to me by telling me to
You
take
told me to take
yeah.
this.
You told me to take this offer. You didn't tell me to take the one with the inspection.
Right, because it'd
You
be
put me in
cleaner.
this situation.
Yeah.
Right.
And now you, as the real estate licensee, after you've told everybody how good you are and what a professional you are and how great you are at your job and how many millions of dollars of real estate you've sold that nobody understands other than realtors, you're now saying,
He's
well, it's
taking
not my
stabs at
job
me.
it's not my job to figure it out. Well, it's not my job to make the decision. It's the seller's decision.
Yeah.
Like, you're struggling to have your cake and eat it too.
Correct. And I think, Heather, the thing that Brett's probably got a little bit more understanding than you and I are, we do things much differently than some people do. So again, he's seeing all the bad stuff that's out there, the people that are going, oh yeah, just waive it, this is going to be the
Right.
best. And then, oh yeah, you want this, it's a cleaner offer. And giving that bad advice instead of saying, hey, look, Kevlar Snuggie, you want this, or hey, I wouldn't waive them, it's not a recommendation. That is a higher quality to your client than going, yeah.
I
Let's just
said right
waive
out,
it.
it's a bad idea.
Mhm.
I had a recently, very recently, a transaction in which the buyers were waiving owner's insurance.
Mhm.
The charge for the owner's policy was $45. And then there was, so it was, there was. an
For those of
endorsement.
you that don't understand, he's talking title insurance.
Title insurance, correct. And I'm the title agent in that, the closing attorney. I don't represent the buyers. But I said to my processor, do a reply all and loop me in on this, because I don't know where they came up with this idea. And I spoke to the buyer's agent, and the buyer's agent said, I think it's a dollars and cents issue. And I said, okay, do they understand that we're talking about $100 at the end of the day? And I said, look, guys, I don't know where you came up with this, but here's what title insurance does. Here's the risk to you. And I'm going to have you sign an acknowledgement and waiver at closing if you don't get it, because I think it's a bad idea and you'll be unprotected. The lender will be protected because they're requiring you to get a lender's policy. I'm recommending that you spend the 45, 50, $60 to get the owner's policy. And 20 minutes later, they responded to the email saying, I spoke to my spouse and I spoke together, and we've decided that we actually do want the insurance. We want the title insurance policy. I said, great. I think that's a smart decision, because, like any insurance, you never want to have to use it.
But in that time you
You
need.
hope it's a waste of money spent that you never needed. But I think the national average, I haven't heard recently if it's gone up or gone down, but in 21 or 22, it was 6% of all residential closings in the United States had a title claim. And what's worst case scenario in a title claim is you lose title. You're out of a house.
Yep, you're done.
You don't get paid for
No
it.
cash.
The person who made the claim for the title gets
Bye.
without paying you for it. The lender's paid off because you have a lender's policy and you're left with nowhere to live and no money in your pocket.
Yep,
So
no equity, no
yeah,
nothing.
And so coming back to, that's on the title side, a little deviation from, but the same thought process applies to the due diligence. Your buyers in your market, this is not the commercial world, because in the commercial world, this conversation would have taken about 7 seconds, because you're doing your due diligence.
Yep,
It's not
End of story.
which
Yeah.
we are
X amount of
so
days.
doing one of those.
Yeah.
And we're gonna bring Barb in.
Yeah.
And let's do one of those,
Yeah.
because I think it'd be helpful for residential people
Yeah.
to hear that it's not even a question over there. Even though there is a waived line, it doesn't get checked very often.
That's one of the reasons that a lot of times in the commercial arena, they don't use the standard form,
Yeah,
because the inspection, the due diligence paragraph is not robust enough. And I can
Yeah.
say that with a lot of comfort because I wrote it. That's how long it's been since that.
It's been
agreement-
touched.
Yeah, it's been touched. I
Yeah.
mean, that was my language. And I know it's not it's an okay form.
yeah.
But yeah,
Needs
so
some work.
anyway, it's not, it is a myth understanding.
Yeah.
It's stated intentionally that the inspections are the death knell of a transaction. Just like it's a misstatement to say you don't want an attorney because they'll screw up the deal. There are some attorneys that will screw up the deal. There are some inspectors and inspections that will kill the deal. But there are more benefits. And as I've said to people, and I think I've said to you, Nick, I'm not in here to kill the deal, but if I kill the deal, understand that
It's for a reason.
killed.
Yeah,
Yeah, so the attorneys get somebody that understands residential real estate for the inspections. Do you need to elect everyone? Of course not.
no,
But look at it with an eye to what are we trying to do as a buyer's agent? What am I trying to do to protect my buyers? Now, I'm so quick to click the liquidated damages clause without understanding what it means. We're going to waive the inspections. On the listing side, it's the same analysis.
Mhm.
Do your sellers want to go to Florida and be done? Do your sellers want to go to Maine and be done? Or do they want to have to worry for the next 2 to 6 years as to whether or not they're going to be called back to Pennsylvania to deal with the problem?
Yeah,
So due diligence does offer a certain
Have
level of
Lars Nugget.
protection to the sellers.
yep.
All right.
Well, guys, I think we also know
That's
the
a
next
lot.
topic. Next topic, I think we're gonna talk about liquidated damages.
Oh, Lord.
Yeah,
Stuff.
we'll have to probably maybe break that up into 2. And then don't forget to follow and share, guys, because we're gonna be having some NAR lawsuit updates. We're gonna be having some PAR form changes that are gonna be rolling out soon that I think we're gonna take a deep dive and help everybody understand in case you're gonna miss out on some podcasts, because I know PAR will roll out some as well to help get everybody up to par with No,
Or-
no pun intended. With all of the changes that are going to be rolling out. So this is not a podcast you're going to want to miss. Thanks, guys.